Welcome back to another edition of Legal Talk. Let's get right to the phones and see who's on the line. We have Mary calling from the North End. Hi, Mary.
Hi, Lloyd. I have a question about my landlord.
Okay, what's your question, Mary?
My water heater broke about 2 weeks ago. I called the landlord the night that it happened, and he still hasn't fixed it. What can I do?
We get a lot of calls about landlords on this show. First, let's talk about what the landlord-tenant relationship is, and then I'll explain how that bears on your question about your water heater. Now, the landlord-tenant relationship is basically a contract between the property owner, the landlord, and the tenant. This contract transfers certain rights to the tenant, such as the right to use and possess property. Now, that's important because it means that the landlord has conveyed these rights and therefore no longer has them. Of course, the landlord gets these rights back once the lease is up. Now, back in the old days, this contract, which we call a lease, would be transferred to the tenant, and that would be it. But quite a few things have changed since then. For one thing, each state now has a series of statutes which impose additional duties on landlords.
Is this like lead-based disclosure and things like that?
Yeah, that's part of it. But more and more states began to realize that when landlords were able to make their own rules, a lot of them would do it in a way that would only look out for their own best interests, rather than the best interests of their tenants. So far, so good, Mary?
Yeah.
Now, under modern laws, when a landlord leases premises to a tenant, there are certain basic guarantees that the landlord must provide. These are sort of like consumer protection laws. The landlord must provide all the basics, things like the walls and the roof and basic livable conditions. If the landlord fails to do that, then the tenant can sue the landlord for violating these state laws.
But my landlord is saying that hot water is not a necessity. He says he'll get to it when he can, that people live for thousands of years without hot water, and I can wait a couple of weeks for him to get the parts that he needs.
Well, that's not how the law works anymore. Under the law, the landlord has to provide premises that are habitable. That means they must be in good repair and be fit and livable. That last part includes things like the walls and the roof and the floors and a lot of other things too. The common areas like the hallways have to be safe and clean of any garbage or obstructions. And finally, most important to you, Mary, the air conditioning, heating, plumbing, and electrical systems all have to be in proper working order. So, Mary, your landlord has an obligation to fix your water heater.
How long does he have to fix it?
The landlord must complete all repairs within a reasonable amount of time.
But he'll just say that it's reasonable for him to wait a couple of weeks.
Well, fortunately, your landlord doesn't get to define the term reasonable. The law does that. For a broken water heater, typically 1 to 2 days is considered a reasonable period of time, certainly not 2 weeks.
Okay, so what do I do?
Well, you have a couple of options. You can file a small claims action against your landlord and the court can order him to make the repairs, or you can also file a complaint against him through the Better Business Bureau.
Can't I just refuse to pay my rent until he fixes it?
Believe it or not, the answer to this question is almost always no.
Why? It seems like the best leverage that I have on it.
Your obligation to pay rent is created by your lease, and you have to pay it. Although you do have another option, you can claim constructive eviction.
What's that?
That's a claim that the landlord has let the property get so bad that for all intents and purposes, you can't live there anymore.
Does that mean I wouldn't have to pay my rent?
No, you'd still have to pay your rent. You'd bring a constructive eviction in court and claim that the premises were so bad that you couldn't reasonably live there anymore. In most of these kinds of cases, you'd keep paying your rent while the case is pending. Only you'd pay it into a court account, and when the case gets resolved, if the court rules in your favor, you'd get it paid back to you. You might also be entitled to further payments from the landlord for expenses you took on trying to fix the problems yourself or for moving expenses. It all depends. In some cases, if the landlord's actions were so bad, the court might also award punitive damages. Those are monetary awards that aren't tied to your expenses but are imposed on the landlord to make an example out of him for the rest of the community.
Would those damages be paid to me?
Yep, they sure would.
So what should I do next?
Well, obviously you've already spoken to your landlord about this, so my suggestion is you send your landlord a certified letter demanding that he fix the water heater. If he doesn't, then that'll be your proof for the civil suit. Chances are, though, that once he gets the certified letter, he's going to figure out what's going on, and before you know it, that water heater will be magically fixed.
I'd like to say a lot more in the letter, let me tell you.
Yeah, I'm sure you would, but let's just stick to the water heater for now.
Okay, thanks.
Well, thanks for your call, Mary. We're going to take a short break, and then we're going to get right back to more of your phone calls, so stay tuned to Legal Talk.